I am protected in that.
Yes.
There are multiple proceedings pending between both the parties. Yes, OBJ, the specific allegation.
Yes.
Let's keep I am protected in. कॉपी नंबर एक में गया मुझे एक देना गया मुझे
Yes.
इसकी तरफ जनता का जैसे कि हम लोगों को ये क्या परिस्थिति के दुकान मालिक थे आवाज जनता का आपसे मुझे आओ इसे शायद करेंगे या फिर देखिए हम कैसे आगे बदलना हो सकता है संदर्भात कौन प्रयास है बोला पुलिस से बड़ा झगड़ा और दूसरा काम करेगा लेकिन सदर करना होगा परीक्षा आरोप there are specific allegations. Paragraph 5.
Yes.
There are also allegations against the parade.
Yes.
बड़े सदर का आरोप जो हमारे रहता है जो अमुक प्रकार आरोप नंबर 4 The investigation total as a special petition could not be proceeded further because there is a stay granted by this honorable court.
Yes. Yes.
And therefore, the charge sheet could not be filed.
What your client is doing by in life. How he has written complaint is filed by him.
Yes, sir. That's page 40B. Why do you प्रकार लिखिए?
So જ્યોતિષ શાસ્ત્રમાં આટલી બધી પરફેક્ટ આવે કમ્પ્લીટ ડિટેલ. સારું કહેવાય. ગોલ્ડ મેડાલિસ્ટ. How you can justify? Nothing but everything is not permissible. To some extent, yes, not beyond a point. This creates a lot of problem in society. Nobody is safe. Yes.
Because what in the basket is on. It's the occasion is there, certain government is
Anmol. As it is, what is the offensive?
Kindly see where in the statement specific application of the instructions number 1, 2, and 3 is used. According to her statement, she says that
try કરી લ્યો હવે એમાં how one number 1 and 2 is
she is saying in the statement that is why I am relying upon her.
yes
as far as only my second alternative, as far as invocation of section 11 is concerned, the intent of whether it is an offense under the section or not, but that is a question of that. Which my respect and submission will be can be determined only at the speed of time. Because under section 11 it is a that it is a question of that which is what the honorable.
Yes.
The aspect is that probably the interim relief was modified. And the police was directed to file charge sheet against or the
For your satisfaction. For what? What you ultimately nothing is.
As far as I will be there, support what my learned friend,
We are encouraging the shortcuts. Nothing.
what
If
my
he-
learned friend is.
Please complain.
That to the honorable court in saying that what my learned friend is.
Is it correct that the DGP has directed them to register the complaint? Ask it. And his complaint is not registered. Whether that is correct or not. Then I can appreciate how the investigation is carried out.
order is in page 77. Order is there.
DGP પેલું જોડાઈ જાય છે તમારી પાસે. What is the interest of why special treatment to your client? And
My lordship, I'm inquiring with regards to the review of the order, but the report which I have submitted. And in the report second, therefore I said that I am being fair to the honorable court, because in the report itself it is stated what my lawyer submit that report in honorable court. Saying that kindly see the second paragraph. On the second page, my lord, kindly see the second paragraph. I am a for my party, so I am not. The Pariyan will grant it. Take no need. Nakwana Mahaman Kita for Science in the News, this is Palan Dance. Rakava, Avarnava, Panther, Santa Katavan, Katavan, so my career is in so as far as that content, but she was and the complainant was called after finding of the this should be discussed. I would like
there is a communication. He has made some representation to the DGP. On that basis, he has asked to inquire. Inquire is a different thing, but if it is directed to register the complaint, that is very.
It is written that પ્રસ્તુત બાબતમાં અરજદારની રજૂઆત અંગે ફરિયાદ નોંધી અહેવાલ સત્વરે અત્રેની કચેરીએ મોકલી આપવા વિનંતી છે. પોલીસ મહાનિર્દેશક અને મુખ્ય પોલીસ અધિકારીના હુકમથી. And then very next page is a society complaint with the DG itself. The entire society has signed.
Yes. I am allowing them. All the petitions are allowed. Give the chart of each matter where the complaint, FIR, detail of FIR, and date of detail, and rather the date of offense, the date of your complaint.
And the short
Give the
one page.
one page in each matter, each other, in each page.
I will. In all.
By end of the day or tomorrow morning, but better today you can,
I'll try.
I can,
I'll just.
for my convenience.
Please.
I can do.
Please. Because you have like that.
Member for Mutaya, Viశ్వాస
નામ બધા લખી નાખજો કોણ કોણ એડવોકેટ તમારી પાસે છે ને? નામ લખી રાખજો. કોના કોના લખી રાખજો.
My lords,
Yes, Mr. Shetty.
this one and the next matter, both are arising out of the same FIR. All the other co-accused in the case, the FIR is quashed. It is a case where Mr. C.R. Patil had borrowed money, taken a loan from a cooperative bank in Surat. He could not repay the loan, and therefore the FIRs came to be filed. The order is at page 303. Ultimately,
How does it make any difference? X has borrowed the loan or Y borrowed. That makes no
very well, man.
name is not material,
I-
or at least
Yes.
for this court.
Yes,
Yes.
it's just on page 303 is the order of this honorable court,
Yes.
whereby
So
the
in whose matters the FIR is?
yes, as far as the 5 directors of the bank, the branch manager, general manager, and the consultant.
Who are you?
And at present, the valuer who provided the valuation certificate and the advocate who gave the title clearance certificate.
You are representing.
Yes, my lords.
You are on better footing then.
Yes, my lords. And in
Yes.
the second matter, the chairman, managing director, and the vice chairman.
In that matter, we will consider the independent. What about this? Value and how they?
One is about the value and the lawyer, my lords. That I quite see. Another one is about the chairman, vice
We
chairman.
will consider that separately. This can go. First matter is allowed.
Grateful to the court.
Yes, second matter.
My lords, second is for the chairman, vice chairman, and the managing director.
The matter is alag છે.
Here the order, the court will find at page 260.
Yes.
The order. Do my lord,
260.
yes, my lords, 260.
So there is one judgment pertains to lawyer if you are advocate whether.
Yes, your lords.
So he has given title
Title
clearance
clearance.
report. I think same analogy will apply to the valuer to some extent.
Please, your lord, certainly. And more, yes.
Come with give the
Please, sir.
citation.
We'll provide it.
I have
No,
just-
two. One is Supreme Court and
One is
2-3 judgment over for this two.
my lords. I have
Must be
also,
many judgments.
yes, I have also put the press note, which after only 8 months after filing of the FIR, the official liquidator put a press note in the that they are willing to sell the land and the title is clear.
Yeah, it's only just
Yes.
two.
Yes, my lord.
Yes.
At page 260, the challenge in the aforesaid applications has been directed against the FIR number so and so registered with DCB Surat. Criminal revision application has been filed by the applicant's borrowers challenging the order dated so and so passed in so and so by the learned magistrate Surat, rejecting the application for discharge. Criminal miscellaneous application has been filed by the employees of the bank, that is the branch manager, general manager, and the consultant. Whereas criminal application so and so has been filed by the directors of the Diamond Jubilee Bank, both seeking quashment of the FIR against them. That is the 5 directors. The other 3 are before this court, who, apart from being the chairman, vice chairman, they are also the directors. The precise fact emerging from the complaint may be stated that the applicant's borrowers tendered an application for loan from the Diamond Jubilee Bank, which is under liquidation. Some of the employees processed the said application and thereafter the same was placed before the directors of the bank for sanction of loan. The loan was sanctioned and the loan amount came to be dispersed to the applicant's borrowers. The allegations leveled are that the amount was dispersed more than the loan sanctioned, and the property which was furnished for the security was found overvalued. Thereafter, the borrowers committed default. Thus, the aforesaid complaint came to be filed. At the outset, learned advocate Mr. Mehta and Mr. Sekhna pointed out that the issue reached up to the Supreme Court, and the Honorable Supreme Court in criminal appeal so and so arising out of SLP so and so with criminal appeal so and so arising out of SLP so and so passed the order dated so and so observing thus. The learned counsel for the appellant now prays that in view of the full payment under OTS, that is the one-time settlement scheme, nothing requires to be done by the appellant. The condition imposed by the High Court in the interim order referred to above does not survive, and his properties may be ordered to be released from attachment and be made available to him by relieving him of the undertaking given by him. In our opinion, the appellant is entitled to the relief sought. In view of the full settlement between the parties and payment made by the appellant under the OTS, now nothing is due and payable by the appellant to the respondent number 4 bank. Accordingly, the properties are ordered to be released. Title deeds and documents, if any, pertaining to the said property be handed over and returned to the appellant by the respondent number 4 bank. The appellant is also relieved of the undertaking given to the court. The appeals are allowed to the above extent. In view of the aforesaid factual position, the revisionists who are the borrowers are seeking discharge from the criminal case and FIR concerning the loan transaction. In the similar way, the applicants who are employees and directors of the bank are seeking quashment of the FIR concerning the loan transaction. Since the entire amount of loan has already been repaid to the bank, there remains to dispute as observed by the Honorable Supreme Court. It should be there remains no dispute. There also appears no purpose to proceed against the revisionists as well as the applicants. Consequently, therefore, the prayer of revisionists seeking discharge from criminal case so and so in respect of FIR in question is allowed, and accordingly ordered dated so and so passed in criminal case number so and so by the learned magistrate Surat, rejecting the application for discharge is hereby quashed and set aside. Similarly, the prayer of the applicants in criminal application so and so seeking quashment of the FIR in question is allowed, and accordingly FIR stands quashed and set aside against them. If the FIR culminated into charge sheet and any other criminal case, the same shall also stand quashed against the present revisionists and applicants. All the three captioned applications are allowed. Rule is made absolute. So, on the ground that all the dues are clear, and as also the Supreme Court has considered in Nikhil Merchant, the FIRs came to be quashed. They are no
There
different.
are different divergent views. I am not inclined in this matter, considering they are chairman, vice chairman, and huge scam, Mr.
No, I will point out, my lord.
Without
Only a
whatever,
moment, my
it's
lord.
a question of trial. Not discretion cannot be used in such a matter at this stage.
I will just point out, my lords.
Looking to their responsibility, statutory duty. Everything is required to be considered, kept in,
No,
not only them.
I will just point out, my lords.
You can
That
find out.
it is-
Prima facie, I have read the FIR. So, and also charge sheet is filed.
Charge sheet is even this case is the FIR
Yes,
came
yes,
to be
yes.
launched. Charge sheet is filed in 2003, my lords. So,
You can argue. There is no difficulty.
no, I will just point out, my lords, because the directors and the chairman managing, they are no different. They have taken a collective decision. And if the FIR against the directors has come to be quashed,
Here it is.
there is no reason why it should be retained against the
So parity. You are seeking parity and quashing petition.
my lords, they are at the fag end of their
Ultimately-
lives.
You can argue. There is no difficulty. As per my understanding, the role of director is lesser than the role of managing director and chairman
It's a
in
collective.
any institution.
It's a collective decision.
Depends
my lords.
on facts of the case. But
It's a collective.
normally
decision.
that is, and they are also having some statutory duty.
No, it's basically a collective
We
decision.
can't permit everybody to
And
shrug off their liability.
the borrower, everybody has been discharged, my lord. So
This person has to face the trial. That is my,
they're at the fag end of their life, my
yes, yes, there is. Go for that.
and there it is the matter has been settled because the payments are made.
Whatever. Ultimately, they get acquittal, but not by way of aborting the procedure at this stage.
In the court,
At the best, I can direct the trial court to expedite the proceeding. If you are having any grudge about the-
no, my lords, that's
Delaying
not
of
the
it.
issue, my lords.
Take instruction. I am not inclined, very frankly.
I may just come better prepared on the next occasion.
Prepared, I am also prepared, so. Whatever preparation is
Otherwise,
in this matter, otherwise.
because what would happen is everybody has been, the FIR is quashed and only the chair.
That, you know, somebody has to face that.
The fact is, my lords, that the branch
On the
manager,
contrary, it will create bad impression in even.
the branch manager, they all create a process note and they forward it to the directors. And thereafter,
For
the
lawyer,
directors
and
approve.
yes, I can understand. They have limited role to play. But preparation will not make any much difference.
No, my lords, what I'm saying is that the process note is prepared by the general manager, branch manager, and submitted to the directors. They have,
Want to order on merit, there is no difficulty. You can argue on the matter. There is no difficulty.
would the court just give me some time to be better
2:30.
prepared?
2:30. 2:30. Take instruction, proper instruction. Better you expedite a trial proceeding can be expedited.
But my lords, everybody else, the FIR is quashed. Only these people, I'll be able to convince the court.
Let the formalities may be completed. In other words, you can get the acquittal if you are so confident that.
But how will the trial take place, my lords? No other accused is there. And the bank is not interested in proceeding with the case.
They will.
The court will just see the
I
Lawat
will
case.
direct the trial court to proceed with
The Lawat case, they have withdrawn from the board of nominees. They have withdrawn. They have also
That
issued.
is unfortunate part. I am not here to make any comment.
But even the
Otherwise,
Supreme.
that is unfortunate.
My lords, even
Once the person are making huge scam and thereafter they are coming with the plea that.
my lord, there is no scam. It is only a banking transaction.
Yes, yes.
It is only a banking transaction, my lords. And
The repayment is itself is not ground for quashing.
what is the role, my lords? They have just sanctioned a loan and there is no rule of filing an FIR. There is no law, even in the Cooperative Societies Act, there is no rule for filing an FIR, mal. Even as per the RBI Act, there is no rule for filing an FIR.
Yes. Yes. There is FIR.
Lords, FIR is at page 101.
Type copy.
The type copy should start at
136.
136.
Read
Yes.
page 136, column number 4 and 5.
Yes, ma'am. Ghulam Hussain Nizamuddin Sheikh, bank manager, કોમતવાળાનું નામ તથા રહેવાનું ઠેકાણું. Thereafter, these are the 14 accused who are listed. Out of them, one had expired. There were 13 remaining. Out of those 13, 8 were already quashed. Left were the advocate and the valuer. So, at present, only the chairman, managing director, and the vice chairman is left, my lords. My lords, before I may begin on merits, may I just request that if some time is given, I'll be able to better convince the court. It's a genuine case, therefore. I'll be able to
Time is
convince
not-
the court.
You can at the best 2:30, not beyond that.
It's a genuine case, therefore I'm requesting.
Every case is
I'll be able
genuine.
to convince the court
For you, this case is genuine. I am considering every case is genuine.
because
But
trial
it should be
proceeding
proceeded.
only against 2 accused, my lords. And
There are 3 accused. How 2 accused?
3 accused. Yeah.
3 accused.
My lords,
Trial cannot be proceeded against one accused if one accused is there.
But this is supposed to be a collective. They have applied sections of 34, 120B and 114.
Everything will go.
According to them, everybody benefited. Now, what is the benefit in this, my lords, in granting a loan?
I don't want to post this quickly. You take chance.
No. Only some time to convince the court, my lords. I'll be better
I'm
prepared.
already convinced. Now, what more you
I will just point out, my lords.
point out? Point out.
Yes. No, the FIR, my lords, on 138.
Yes.
એવી રીતની છે કે ઉપરોક્ત બતાવેલ અને જગ્યા ઉપરોક્ત અમલદાર બેંકના જાહેર નાણાં લોનના નામે ઠગી લેવા કાવતરું ઘડી કાઠી તે કાવતરું સમાન હેતુ અને ઈરાદાથી એકબીજાની મેળાપડીમાં અને મદદગારીમાં પાર પાડી બેંક સાથે વિશ્વાસઘાત અને છેતરપિંડી કરી ફોજદારી દસ્તાવેજ ઉભા કરી તે આધારે તથા મનસ્વી રીતે લોન પેટે કુલ રૂપિયા 100 કરોડની ઠગાઈ કરી ગુનો કર્યા વગેરે બાબત. Thereafter on the next page, the Diamond Jubilee Cooperative Bank, Sahkari Bank, જેની રજિસ્ટર ઓફિસ so and so મુકામે આવેલ છે તેના તરફે સદરના વહીવટદાર શ્રી so and so તથા તેમના અધિકૃત અને ફરિયાદી બેંકના મેનેજર ગુલામ હુસેન નિઝામુદ્દીન શેખ જાતે so and so ધંધો so and so નાનપુરા સુરત. Thereafter the list of the accused is given. Thereafter on page 141, the sections which are registered, my lords. It is under section 408, 409. Thereafter 420, 467, 471. Now in this case 114, 120B and 34 are applied as if they have collectively committed a crime, my lords. Now 408 and 409 relate to criminal breach of trust by a clerk or servant. My lords, they are neither the clerk nor the servant. 467 and 471 contains to forgery of valuable security. My lords, there is no allegation against them of committing any forgery. And 471 is using the genuine forged documents or the electronic records. The case is, my lords, that they sanctioned a loan against a mortgage of the valuation of the property is done at 69 crores. Against that, they first sanctioned a loan of 30 crores and subsequently a loan of 11 crores. So there is sufficient mortgage value available, my lords. And the procedure as prescribed by the law is that in case if the borrower is unable to repay the loan, the bank sells the loan, sells the mortgage property and recovers the loan. In this case, it was much lower. Against the valuation of 69 crores, the mortgage, the loan granted was about 30 plus 11 crores. So they could have sold it and recovered the land. My lords, therefore, in the first case, there is no cause of filing an FIR in the case. Not only that, I will point out that subsequently, when the matter came before this Honorable High Court, this Honorable High Court ordered that why is this criminal litigation going on? You dispose of the land and you recover the dues. And that is how the press note came to be granted. Press note came to be given in the newspaper that we would like to dispose this land and anybody interested in purchasing may kindly approach the official liquidator, my lords. No, my lords, this is as far as the sections are filed. The FIR is filed. અમો ફરિયાદી નમ્રતાપૂર્વક ફરિયાદ હકીકત એવી રીતની છે કે અમો ફરિયાદી દી સો એન્ડ સો બેંક સોસાયટી એક્ટ રજિસ્ટર થયેલ સંસ્થા છીએ. ફરિયાદી બેંક અમો સો એન્ડ સો મેનેજરના હોદ્દા ઉપર. I may just point out that the procedure was that first there was an adverse clearing of 1 crore and therefore the registrar Gandhinagar directed the registrar Surat, the district registrar Surat, to take over the bank because it is a cooperative bank. And subsequently, it was handed over to the official liquidator. The FIR came to be filed when it was with the district registrar Surat, my lords. Now, the person who has filed, he is the manager legal of the bank. Subsequently, he was also suspended from service. બેંકના વહીવટ માટે હાલના નામદાર સરકારશ્રીઓ વહીવટદારને નિવૃત્ત કરેલા છે અને તેઓ શ્રી હાલની ફરિયાદ આપવા માટે અમોને અધિકૃત કરેલા છે. તે મુજબ અમોએ આ ફરિયાદ આપ સાહેબ સમક્ષ સાદર રજૂ કરી છે. ફરિયાદી બેંકના રજિસ્ટર ઓફ ઓફિસ સો એન્ડ સો સુરત મુકામે આવેલ ફરિયાદી બેંકના સુરત શહેરના કુલ 60 શાખાઓ આવેલ છે. ફરિયાદી બેંકનું કાર્યક્ષેત્ર સુરત મ્યુનિસિપલ વિસ્તાર ઉપરાંત નવસારી, ભરૂચ, નર્મદા જિલ્લામાં પથરાયેલ છે. તમામ શાખાઓનું વહીવટી મંડળ બોર્ડ ઓફ ડિરેક્ટર્સ કરે છે અને તેઓ આ વહીવટી બેન્કિંગ રેગ્યુલેશન એક્ટની જોગવાઈ મુજબ તથા રિઝર્વ બેંક ઓફ ઇન્ડિયાની ગાઈડલાઇન્સ મુજબ તેમજ સરકારી મંડળીય અધિનિયમના જોગવાઈઓ અનુસાર તથા બેંકના પેટા નિયમો અનુસાર કરવાનું હોય છે. આ કામના આરોપી નંબર વ્યવહારો સમયે બેંકના ચેરમેન હતા. આરોપી નંબર 2 અને 3 વાઇસ ચેરમેન અને મેનેજિંગ ડિરેક્ટર હતા. આરોપી નંબર 4 થી 9 ના બેંક ડિરેક્ટરો હતા. આરોપી સો એન્ડ સો ફરિયાદી વ્યવહારો વખતે ઉપર મુજબના હોદ્દા ઉપર અને આરોપી નંબર 10 શ્રી સો એન્ડ સો વ્યવહાર વખતે બેંકના જનરલ મેનેજર હતા. આરોપી સો એન્ડ સો વડ સલાહકાર અને ચાર્જમાં હતા અને આરોપી નંબર સો એન્ડ સો શાખા મેનેજર હતા અને તેઓ આરોપી નંબર 1 થી 9 નાઓની સાથે સક્રિય વ્યવહારોમાં હતા. બેંક સહકારી સંસ્થા છે. તેના નાણાં જાહેર નાણાં છે. ઉપયુક્ત હોદ્દાઓની રૂએ બેંકની રકમ અને થાપણ ઉપર આરોપી નંબર 1 થી 9 સુધી અધિપત્યો અને બેંકના રકમ અને થાપણ તેમના નિયંત્રણમાં હતા અને તેમના વિશ્વાસી હતા અને એ રીતે તેમના નિયંત્રણમાં અને તેમના વિશ્વાસી બેંકના જે રકમના અને થાપણો હતી અને તેઓ ટ્રસ્ટી કલમ મુજબ એટલે કે બેન્કિંગ રેગ્યુલેશન એક્ટની જોગવાઈઓ મુજબ રિઝર્વ બેંક ઓફ ઇન્ડિયાની ગાઈડલાઇન્સ મુજબ તથા સહકારી મંડળીની અધિનિયમની જોગવાઈ અનુસાર તથા બેંકના પેટા કાયદા મુજબ તેઓ સદરુ રકમ અને થાપણોનો વહીવટ કરવાનો હતો અને ફરિયાદવાળા વ્યવહારો માટે તેઓ તમામ જવાબદાર હતા. આરોપી 13 ભારતીય કંપની દ્વારા હેઠળ નોંધાયેલી કંપની હોવાનું જણાવી અને આરોપી નંબર 14 થી 16 નાઓ ડિરેક્ટર હોવાનું જણાવી આરોપી નંબર સો એન્ડ સો ફરિયાદી બેંક સાથે ફરિયાદમાં જણાવેલ વ્યવહારો કરેલા છે. આરોપી નંબર સો એન્ડ સો ચાર્ટર્ડ સિવિલ એન્જિનિયર અને ગવર્મેન્ટ એપ્રુવડ વેલ્યુઅર છે અને એડવોકેટ છે. ફરિયાદી બેંકના લિક્વિડિટી ઘટી જતા
Read the relevant.
Yes, yeah, my lords, I will just, it's a
There is no end.
very elaborate FIR. The crux
Read
of
page 156.
the crux of the FIR is
Read
that
page 156.
all these persons in connivance with each other have granted this loan for illegal gratification. Now, my lords, what is the illegal gratification? What have they received out of it? There has to be some illegal gratification, my lords, to prove a case, my lords. And is there a provision in law when a borrower is not able to repay the loan that an FIR should be filed? The normal course is that the bank liquidates the mortgage property and recovers the dues, my lords. And in this case, he was not the only borrower. Apart from him, there are so many borrowers. When the bank went into liquidation, there were so many other borrowers. No FIR is filed against any other borrower. What is the particular reason why only FIR should be filed in this case, my lords? There has to be some answer to that. Otherwise, in every case when a borrower is not able to pay money, the FIR should be filed, my lords. 156, the court wants me to read. Or may I? 156, my lord.
156.
Yes. આરોપી નંબર ના ખોટા વિશ્વાસ અને ભરોસામાં જાણી
That
બુજીને
is somewhere in bottom. Just
તારીખ 12/1/2000
અને લિસ્ટ ડીડ ની શરતે પ્રમાણે જીઆઈડીસી માં જો શરતે ટર્મિનેટ કરો તો લિસ્ટ ડીડ ના થાય.
લીઝ ડીડની શરતે અને લીઝ પ્રમાણે જીઆઈડીસી માં જો શરતી લીઝ ડીડ ટર્મિનેટ કરે તો લીઝ ડીડના આધારે ફરિયાદી બેંકે જે ઇક્વિટેબલ મોર્ટગેજ કરાવી લીધો છે જે મોર્ટગેજ પણ રહે તેવી સ્થિતિ છે. તેથી આવું ધિરાણ જમીન વગરનું ધિરાણ બની જાય તેવી સ્થિતિ છે અને અત્રે ખુલાસો કરવાનો કે સો એન્ડ સો ના રોજ ઇક્વિટેબલ મોર્ટગેજ કરાવેલું હોવાનું જણાઈ આવે છે અને સદરનું ઇક્વિટેબલ મોર્ટગેજ તે જ તારીખે દસ્તાવેજ નંબર સો એન્ડ સો મહેરબાન સુરતના સો એન્ડ સો રૂબરૂ નોંધાયેલ આવવાનું જણાઈ આવે છે. તેમાં પણ લીઝ ડીડની નકલ ડિપોઝિટ કરવાની હોય તેમ જણાતું નથી, પરંતુ લીઝ ડીડની રજીસ્ટર્ડ કર્યાની રસીદ ડિપોઝિટ કરેલ હોય તેમ જણાય છે. એ જ હોય તે પરંતુ લિસ્ટેડ શરતી હોય અને શરતોનું પાલન થયું નથી અને તે પાલન થાય તેમ ન હોવાનું જાણવા અને માનવાનું કારણે હોવા છતાં આરોપી નંબર સો એન્ડ સો એકબીજા મુક્ત અને ચોખ્ખી ટાઇટલ વાળી મિલકત હોવાનો અભિપ્રાય આપ્યો છે અને આરોપી સો એન્ડ સો. Now, my lords, after
Next paragraph. So that is pertains to security. Now, next paragraph, 10.
I will just point out, મૂળ અરજીમાં જણાવ્યા મુજબના કેટલાક દસ્તાવેજ રજૂ કરવાની દરકાર લેવામાં આવી નથી. ઇન્કમ ટેક્સ એક્ટ મુજબનું સર્ટિફિકેટ લાવવાનું હતું તે નથી, તેમજ શહેરી જમીન ટોચ મર્યાદા સો એન્ડ સો મુજબનો ડેક્લેરેશન પણ પ્રોપર પર જણાતું નથી. વાર્ષિક આવક અને વાર્ષિક ખર્ચનો પણ અરજીમાં કોઈ ફોડ પાડેલ નથી તથા ઇન્કમ ટેક્સ એસેસમેન્ટ ઓડિટ પણ ફાઇલમાં નથી. બેંક રૂપિયા સો એન્ડ સો ઉપર જણાવ્યા પ્રમાણે સો એન્ડ સો ના રોજ મંજૂર કરેલા રકમ આરબીઆઈ ના રિપોર્ટ પ્રમાણે મંજૂર થઈ શકે નહીં અને આ સંબંધે બેંક આરબીઆઈ ની ગાઈડલાઇન્સ નું ઉલ્લંઘન કર્યું. So, my lords, therefore, the procedure is that the RBI can condone this or a penalty can be imposed, my lords. Now, RBI has never issued a notice. It has never imposed a penalty. But there is no provision of filing an FIR, neither under the RBI Act of 1949, neither under the Cooperative Societies Act, my lords. Because in this case, when the bank went into liquidation, there were other debtors also. But why they have selected only one person to file the FIR, my lords? If in that case, now, my lords, after making all these allegations in the FIR, the court may just see page 298, my lords. The last.
Your IO is here. Not present. Why? So, serial number 2 and 3 in
Sir, 2 days, there is some difficulty. The board handled late. Therefore, my lord, not just able to send him advance communication.
yes.
My lords, the last page, the court may see page 298. Now, after making all these allegations in the FIR, this press note is given just 8 months after filing of the FIR. And this was pursuant to the direction of this honorable court that why these criminal proceedings are going on, you sell the property which is mortgage and recover the money and put an end to the matter. I will point out that order also if the court would like to see. Now, my lords may see this press note. It is given by the respondent too. It is in their name, the Diamond Jubilee Bank. It says Sachin GIDC ની વિશાળ જમીન મિલકતનું વેચાણ નામદાર હાઈકોર્ટના હુકમ અનુસાર. The press note begins with નામદાર હાઈકોર્ટના હુકમ અનુસાર વહીવટદાર શ્રી ડાયમંડ જુબલી કોઓપરેટિવ બેંક લિમિટેડ સો એન્ડ સો GIDC તથા શ્રી CR સો એન્ડ સો ના સહયોગ વડે નીચે દર્શાવેલ જમીન મિલકતોના વેચાણ માટે ઓફરો
What
આમંત્રિત કરે છે.
happened thereafter?
My lords.
Thereafter, what happened?
My lords, thereafter, subsequently, the borrower only made the arrangements and he cleared all the dues. And my lords, I am making a statement that this is the only bank in the country under liquidation which is showing a surplus of 50 crores. The court may kindly see it is on record, my lords. There was no wrongdoing, my lords. It was only a case where he couldn't bring the money. And therefore, the bank went into liquidation. And there were other mitigating factors which I have put on record.
Put it
Would be-
right. Day after tomorrow.
May I request for Friday, if convenient to the court, my lords.
You are some
I'm in the-
anticipating some further development.
No, my lord, I am in the hands of the court. I leave it to the court.
Then I can accommodate you.
I am in the hands of the court.
The prima facie morally, it's
No, my lord, I will
Good
convince
case
the
on-
court, my lords. It
Law-
requires consideration there. Otherwise, I would not have,
not with you, but later take your chance.
otherwise, my lords, I would not have pressed, but it
I will try
requires.
to
Hmm.
see that
May I
can
just
be
read,
as often as I should be.
may I just
I
read 3
don't-
lines from here on, my lords? Only 3 lines. It says that High Court na hukam anusar, they are giving this press note.
All these things are subsequent to the FIR. We have to consider FIR as it is.
My lords, that's the question, that Can an FIR be filed?
Yes, yes.
There are so
certainly.
many borrowers who are not able to repay the money.
Certainly, that is not good ground to quash the FIR.
And I will point out, my lords, from the
Point
record,
out,
the
that aspect I am well aware about the position of law. FIR can be filed and it can be filed selectively also. There is no difficulty.
no, my lords, I will point out from the record that they first took opinion.
Parity or principle of parity will is not applicable in filing.
My lords, they took opinion from the police commissioner's office, and the police commissioner's office gave them a clear-cut opinion that this is a civil dispute.
That is different thing.
You dispose of the mortgage property and recover the dues. Where is the question of filing FIR?
Let the IO may also be. This matter is heard to some extent. Mr. Shetna seeks time to place some more material on the record to in support of his submission. He has argued at length before this court.
My lords may not say at length. Requesting my lord.
And Mr. Let the learned PP call for the report and necessary papers from the IO, so that on next date of hearing, the matter can be put to an end, logical end. Release this matter on which date? Now choose your date.
My lords, 20th, if convenient to the court, my lords.
20th.
Yes.
20th August.
No.
September. August is a holiday. 20th August. 19th.
Any date that the court thinks fit, my lords.
Then let it be on Friday.
My lords.
Friday.
My lords, only I apologize. I need to press because it requires a little consideration.
No issue. It is your duty. I have to also take care of the
And I have put everything on record,
time
my
of the
lords.
court is also precious. We should also
Yes, ma'am.
keep this thing in.
Very well, my lords. Very well.
You are having only, you have to care for about your matter only.
I appreciate,
to
my lords.
care for my entire board.
But
It is only anxiety.
this is the only sum and substance that a borrower has not been able to repay and there is an FIR.
We can't press the matter beyond a point. Some first matter is disposed of, second is adjourned.
My lords are keeping on this Friday, my lords.
So this Friday,
Yes.
this Friday.
And
Next Friday.
any date that the court thinks would.
As you wish. I recorded that you argued the matter. This Friday,
Any date that the court thinks. fit.
this Friday.
But court may kindly not say at length. I have to point out many documents, my lords.
At length, and he still wants to submit something on the record.
I have put all the data on record. I may be allowed to point it out. So if
Yes, yes.
the court says at length, I may
Length is not a good word
not be able to canvass it. So
to some extent.
grateful. I'm deeply grateful.
Yes.
How to solve multiple analysis.
Yes.
I'm unable to contact my clients, Lord. I'm not
It
receiving
says
any
that the
instructions.
child must.
Because we may declare no instructions, Lord. We may declare no instructions, Lord. Because they are not responding, Lord. And it is
File-
2018 matter 138.
File the appropriate note then.
So then I'll
Then
do
I
it today, my lords. I'll do it today because up till yesterday I tried to contact, but it was not possible.
The learned advocate, Mr. Mangukia, has submitted that client is not in contact with the present client is not in contact with the therefore he needs to file necessary note before this court. Let the note such note shall be filed after complying the provisions of the Gujarat High Court advocates rules, Gujarat High Court rules. Release this matter on 1st of August. First August, top of the month,
Okay.
top of the month, first of August.
Number 8, Nanavati and Nanavati.
Yes,
Chief of one Boxy.
Here I am asking for. Here I am asking for.
time 2:30.
The reason is that I just went towards the office. This coming is one. Maybe more by 1:30, I will instruction.
2:30.
Lordship, 230 Mr. Nanavati has already fixed up an anchor before division bench of the school. So if this matter. can be
Yeah,
kept-
officer is coming, so ask him to be here. We will consider that.
130, Lordship, we may take our chance at 130 if.
Question for 1:30.
1:30. 1:30.
I have
1:30.
called my officer in case of difficulty, I will attend.
1:30.
We will take our chance at 130.
1:15. So ideally 1:15 recall will start.
Lordship,
9, Mr. Ajay Pandav, 150, Ms. Richa Shah.
Why, Mr. Pandav, you are not available?
Your Lordship, actually some personal
So many
difficulty, I
days.
was on leave not your Lordship, therefore matter was added to me. There is some genuine reason, therefore I filed the leave not your Lordship. There was some, your Lordship.
Yes, what is matter? 498 days.
Yes, my against the husband, father-in-law, mother-in-law in Nanan, your Lordship. So far as husband is concerned, that was the order that not pressed for the husband, your Lordship. Stay was granted by this court for father-in-law, mother-in-law and Nanan, your Lordship. Proceeding before the trial court is only for recording plea. It is on 17 August, it is listed for the trial court. Now, allegation against the present petitioner, your Lordship, that is just I will point out, your Lordship. Page number 16, 18, your Lordship. That marriage is on 2013 and FIR is registered in 2021, your Lordship. Page number 18, may kindly see. FIR.
Marriage is registered. Marriage is of year.
Marriage is on 13 May 2013.
Yes.
FIR is on 2nd June 2021.
So 2020. Yes. 20, 21. Yes.
21. Page number 18, your Lordship, that common allegation in the FIR, Lordship. Last paragraph. That મારા લગ્ન તારીખ 13/5 રોજ નડિયાદના રહી સોયનસોના દીકરા નિરંજન સાથે અમારા રીત રિવાજ મુજબ કરેલા. લગ્ન બાદ હું મારી સાસરીમાં મારા પતિ સાસુ સસરા સાથે સંયુક્ત કુટુંબમાં રહેતી હતી અને 2 વર્ષ જેટલું મારા પતિ સાસરી વાળાએ સાહિત્ય રાખેલ. ત્યારબાદ મારા પતિ સાસરી વાળા મને પિયરમાં આવવા દેતા ન હતા અને ઘરના નાના નાના કામકાજમાં વાંગનો કાઢી મને હેરાન પરેશાન કરતા હતા અને મારા પતિ સાસરી વાળા મારા ઉપર શક વહેમ રાખી મને હેરાન પરેશાન કરતા હતા. તેમજ મારા પતિના ફોન ઉપર કોઈ અજાણી છોકરીનો ફોન આવતો, જે બાબતે હું કંઈ પણ પૂછતી તો મારા પતિ મારી સાથે બોલાચાલી કરતા. છતાં હું મારો ઘર સંસાર સારો ચાલે તેમ વિચારી આ તમામ ત્રાસ સહન કરતી હતી. ત્યારબાદ મને સારા દિવસો રહ્યા. સોયનસો સંતાનમાં એક દીકરા મૌર્યનો જન્મ થયેલો. ત્યારબાદ જીયાણા માટે મારા પિયર આવેલ તો મારા પતિ મને કહેતા કે તને રાખવી નથી અને તારા પિયર વાળા દિન કંઈ આપેલ નથી, તારો બાપ સોયનસો છે તેમ કંઈ મહેનટોણા મારતા હતા. જેથી મેં આણંદ કોર્ટમાં ભરણ પોષણનો કેસ કરેલ. જે કેસ ચાલી જાય ખોરાકી બંધાયેલ, પરંતુ મેં લીધેલ નહીં. After birth of the child, your Lordship, she was with her parents from Anand, your Lordship. અને મારા પતિએ નડિયાદ કોર્ટમાં કેસ કરેલ. તે વખતે મારા પતિએ કોર્ટમાં જણાવ્યું કે અમે અમારા સમાજના વડીલો મારફતે સમાધાન કરીશું. તેમ જણાવતા અમે સમાજના વડીલો મારફતે સમાધાન 2018માં કરાવી મારી સાસરીમાં ગયેલ અને થોડા દિવસ સાહિત્ય રાખેલ બાદ મારા પતિના મોબાઈલ વોટ્સએપ મેસેજ આવતા હું જોતી તો મારા પતિ ગુસ્સે થઈ જતા અને કહેતા કે તારે અહીં રહેવું હોય તો મારે જમીન લેવી છે, ગાડી લેવી છે તો તારા પિયરમાંથી 7 લાખ રૂપિયા લઈ આવ તો જ રાખીશ તેમ જણાવેલ. તો મેં જણાવેલ કે મારા પિતા સિક્યુરિટીમાં નોકરી કરતા હોય, આટલી મોટી રકમ કેવી રીતે આપે તો મારા પતિ એકદમ ગુસ્સે થઈ ગયા અને મને કહેવા
Yes.
લાગ્યા.
Who is for the complaint?
After that,
What is the allegation against father-in-law and mother-in-law? મારો દીકરો કહેશે એમ થશે ને એ અમે નહીં તો કઈ રીતે રાખી શકીએ. That is what. That is 498. How it can? How?
Even the after the state order has been there, even the maintenance amount has been not been deposited by the husband members. Even the maintenance amount has been not been deposited by the husband members.
Your Lordship, that is receipt is here, Lordship.
None of the
no.
amount has been deposited. At
Ye-
least some amount, at least for the regular of the routine life, they need some of the amount, my lords.
Here, Lordship,
That is different thing. It's the maintenance.
maintenance application is pending. Your Lordship, petition is also filed before this court as
How
per
the
this honorable court.
Mother-in-law and
I deposited.
mother-in-law can be even sister-in-law is also implicated. What is this? Can be. Yes. What is the allegation? Read the bare reading of the FIR is. It's a classic example of
Sister-in-law staying separately, separate staying.
whatever. Ultimately, it's a see the even a bare allegation as if the present petition is filed for following prayers. Heard learned advocate Mr. Pandav for it. You want to add anything?
No, only.
Why you are playing hide and seek with this?
Your Lordship,
So many days you are not available. On this count, I am not inclined to grant
Your
it.
Lordship, I was on leave note and sick note, Your Lordship. Only for
Yes.
that reason, Your Lordship. Otherwise, Lordship,
After this, how many years in practice you are in? About
2001
20
year,
years.
23 years, Your Lordship. But some genuine
You
reason,
should
I tender my apology.
Know that how to.
Some-
Don't create bad impression for the. I am not considering the who is representing the case, but at the same point of time, very difficult to adjust the board.
I'm sorry, ma'am.
And sometimes the board feels that the concerned advocate is avoiding the procedure. So following prayers. Brief facts of the case are as such that heard learned advocate Mr. Ajay Pandav for the petitioner. And what is your good name? Richa Shah for the respond number 2. Learned advocate APP Mr. Jaiswal for the state. Mr. Pandav has submitted the prima facie no case is made out against the father-in-law, mother-in-law, and sister-in-law, who are the remaining petitioner in the yes, the petition qua the husband, the applicant number 1 is already not present by and which and permission to that extent is already granted by order dated 21/10/2021. Therefore, the present petition is considered for applicant number 2, 3, and 4, who are husband, father-in-law, mother-in-law, and sister-in-law of the complainant. He has submitted that the marriage is taken place in the year 2013 and FIR is lodged in the year 2021. Thereafter, from the bare reading of the FIR, it transpires that there is a allegation. It's mainly leveled against the husband, pertains to some incident. Incidents have taken place. And the name of the present applicants number 2 to 4 are wrongly given in the FIR with a view to drag the entire family members in the said offense. On the contrary, from the reading of the FIR, it transpires that he further submits that on the contrary, reading of FIR transpires that the father-in-law and mother-in-law have tried to resolve the dispute with the help of the other members of the caste or with the other members of with the help of near relatives. Yes, Ali. And when considering the in totality, FIR in totality, no ingredients is satisfied against the present applicants number 2 for section 498A and 5062 of the Indian Penal Code. Therefore, he has submitted with the continuation of proceeding. Age of present petition number 2 and 3.
Petition number 2 is 60 years.
Present petitioner
And 3 is 55 years.
3 are also aged person. And number 4 is married sister who are falsely implicated in the FIR. 4 with a view to arrest the entire family members of the husband. And therefore, he has the continuation of proceeding pursuant to the FIR will amount to misuse of process of law. But in view of the judgment of Pajanlal and other judgments of Honorable Appeals Court, this court should exercise powers under Section 482 for pushing such to prevent abuse of process. Per contra, learned advocate Mishra appearing for the complainant has submitted that the prima facie offense is made out from the head. The applicants number 2 and 3, being an elder of the family, should take more care about the harassment received by the complainant. And considering the allegation in the FIR, prima facie case is made out under Section 498A, read with Section 5062, and there should the applicants should ask to face the proceeding of trial, and therefore praise to dismiss the petition. Mr. Deswal appearing for the state has also submitted that the prima facie case is made up, and therefore court should not exercise this jurisdiction under Section 482, which should be exercised very sparingly. And in the present case, let the trial may be proceeded. And therefore, he prays to dismiss this petition. I have considered the rival submission made at the bar. I have considered the provisions of Section 498A, 506 to Indian Penal Code, which reads as on the tenor of the FIR, considering the tenor of the FIR. There is general allegation, and the governments disclose that when there is some conflict as a dispute has arisen between the husband and wife, the wife has complained to the father-in-law and mother-in-law about the same, about the conduct of the husband. And at that point of time, they have said that we can't say anything to the son. And even considering the allegation against level against the sister-in-law, that is also in general in church, and no specific allegation which can be considered that prima facie offense is constituted under section 498 or 5062. And considering the fact that now nowadays when there is some matrimonial dispute has arisen between the husband and wife, now it is normal practice that complaint is also filed under section 498 of the Indian Penal Code with a view to implicate the entire family members by the wife. In a given case, the complaint can be considered as genuine, but in the case like the present case, such complaint is nothing but an abuse of process of law, which is filed with the intention to arrest the entire family members for the essential dispute essentially between husband and wife. Therefore, this court is of opinion that the powers under section 482 is required to be exercised in view of the judgment of Bhajan law, and by quashing a impugn FIR and consequential proceeding pursuant to the FIR. बाद में वो 2-3 paragraph accordingly petition is allowed. Petition number 2 to 4.
I'm very much obliged. Grateful. Your Lordship, may I have one more request, Your Lordship? Proceeding before the trial court, the husband, and that may be expedited, Your Lordship. So since long back, Your Lordship,
Why I should observe that?
since it is pending for plea, Your Lordship, till date, Your Lordship.
Now you are not pressing for number 1. Let the trial court.
Please, I'm very much obliged. And tender my apology, Your Lordship. That
No. I'm just.
there was some genuine reason, therefore I was on a leave here.
I am observing.
Grateful to
Last so many occasions you are not available. So yes.
Then Mr. Sivan Gandhi, Mr. Vasant sir, and
Yes. Mr.
Here, I've taken consent of my learned friend Mr. Shah.
Which matter? Is the trial? Why you are asking for? You are not active director. That is your contestant. That can be tested at the time of trial.
Another development is yesterday I was informed by my learned friend Mr. Shah, who is appearing for the complaint, that the trial is completed, the judgment is also pronounced by the trial. I have to
Take instruction day after tomorrow. I am keeping this. If that is so, then the matter becoming practice.
It may be
Take instruction. Mr. Jani submits that as per his instruction, the proceedings are concluded before the trial court. Let to verify the same. He seeks time day after tomorrow from the court.
Please manage. Obliged.
A1 and 12, Sumita Gupta, Inka Digwar Patel.
Before my learned friend begins, I would like to point out one aspect. Look, at the time of issuance of a notice, with profound respect, a wrong statement appears to have been made. Lord, if my lords see the note, if my lords are having matter 1094 on hand, the group of matter 1094, wherein the order is there, all matter order is similar, but my lord, dated 13th February 2020. But there is an order dated 13th February 2020.
Yes.
Yes, order dated 13th February 2020.
Yes. Sir.
Prima facie, it appears that disputed checks annexed at page 32 is issued from joint account held by the applicant and co-accused. And further check does not bear signature of the applicant. Now, check is not from a joint account. It's an account of a partnership. The joint account stands on a different footing than account of a partnership. In all matters, my lord, the accounts are of partnership. Therefore, my lord, it's not a joint account. Honorable Court. This is what subject to that.
There were 15 matters. 9 matters have been disposed. And in same line, those were from joint account. And at that time, it was as serially those were listed. Therefore, that may be.
Yes, yes.
Maybe a bona fide mistake. I'm not saying
Ignore
it
this.
was done deliberately.
Now, what is your contention?
But here the petitioner is the wife of the person who has signed the check.
It's a partnership firm.
His partnership.
Yes.
He has not, she is not the signatory of any of the check here. But she has been arraigned as accused in all the
Notice
cases.
correspondence is there.
Yes.
Notice correspondence is there.
Notice-
Whether you have replied to the notice.
I have replied, but the complainant is denying that I have replied.
Yes.
And a plea has been recorded before filing of the petition.
Yes, not. Everything is on record. I have submitted. Complaint is at page number 25 also, of 1094.
Yes.
Accused number 1 is Saligram Developers. Accused number 2 is Saligram Developers na Bhagidar Rajesh Natwarlal Mehta, and 3 is Rupalben Rajeshbhai Mehta.
Yes.
I am for the number 3 accused number. Here the first, second line of the complaint.
Yes.
आरोपी तथा तेवोना पत्नी, मतलब आरोपी, that is clear for the complainant that आरोपी is Rajesh Natwarlal Mehta who has signed this. आरोपी तथा तेवोना पत्नी બંને સાલિગ્રામ ડેવલપર્સ નામની રિયલ એસ્ટેટ ડેવલપમેન્ટના ધંધો કરતી રજિસ્ટર્ડ ભાગીદારી પેઢીના ભાગીદાર છે. In 50 matters, he has intentionally made her accused, and on same day, all the checks have been deposited into the bank, knowing all the facts.
Yes.
Number 3, આરોપી તથા તેઓના પત્ની આ સિવાય સાલિગ્રામ ડેવલપર્સ પ્રાઇવેટ લિમિટેડ નામની રિયલ એસ્ટેટ ડેવલપમેન્ટ ફેમિલી કંપનીના બોર્ડ ઓફ ડિરેક્ટર્સ તરીકે પૈકીના ડિરેક્ટર્સ છે. Next,
What is stage of trial proceeding?
trial is proceeding for the 2 accused persons, and under section 143A, an application was filed by the complainant, and that was ordered for 20%. That was filed revision against the said order, and that has been remanded back to the trial court. It is the stage now.
Because it can't be retrospective. Therefore. Yes. But I am not, now the law is well settled, madam.
That's it.
So 140, read the section 141.
She is not the signatory of this.
Read section 141. Presumption is there.
There are so many judgments of.
Judgments are on both the account. You can cite any judgment. Whether you have given any reply to the notice.
Yes, Lordship, I have given.
Where is that? Produce that.
I have produced that also.
Yes.
Page number 63.
Yes.
63 is, Lordship, actually, the complainant is denying this, page number 59.
65 is your reply.
Yes, 59 is the first reply when the advocate of the accused persons were not present, and therefore he wrote, they both wrote that reply will be given after few days. They are also denying the same. And thereafter detailed reply was also sent, and that was also received by the advocate of the complainant and by the complainant. And
Yes.
that has also been denied. Reply is at page 65.
Yes. Yes. So what is your contention in the present matter,
The check which was given in the year 2012
2012? Yes.
as security, as there were business transactions going on in between the complainant and the accused person. That was for the security purpose. Thereafter, the complainant found the accused person to hand over 60% shares of the private limited company. Thereafter, he will provide finance. But after receiving 60% of the shares, he did not. Thereafter, he demanded 9 shops to be registered in the name of him or his relatives. And thereafter also, he made the same. He also transferred properties in his name, but thereafter also he did not finance. And thereafter he was pressurizing both of them to hand over other shares of 40%, rest of the shares, then he will provide. And they have not given him the same. And therefore, he is not providing any financial assistance. Now the project is stalled. Nothing is going on. But the complainant is dealing with finance. And therefore, he is showing that he is working on that project, though the project is not going on operating. But he is using the company's account to show entries of his other accounts. Police complaints have been made, but nothing has been done till date. Even criminal inquiry case has been filed. Verification of the complainant is still pending. And another applications have been lodged before the office of the Kacheri of the is
Whether it is your case that you were not partner at the relevant point of time, any point of time, at the time during transaction, or
actively taking part in the business.
that is your plea to that extent that you were not active partner. But it is not your case that you were never partner
No.
or resign as a partner.
No.
Yes.
Even active partner, maybe that is also not their case in the like.
Yes.
They said admitted we are partners.
Therefore, I was.
See, no partner. I am not denying that he is not the
Then it's a matter of question of trial, madam. How I can exercise my discretion at this?
partner.
You can produce whatever you.
The other ground is that the complaint filed is time barred as per my submission. Because the complaint filed by the, as per the record of the computer, it was filed on 18th February 2019. And notice was issued on 24th December 2018. And it was there say that notice were received by the accused persons on 27/12/2018.
Which is the date of notice?
Date of notice is 24/12/2018. It is at page number 26, para 7.
Yes. Then
And it was received as per their statement that received by the accused person on 27/12/2018.
yes.
And the complaint was filed on 18th February 2019.
Yes.
Therefore, it was It was filed after 45 days of. And even they are not admitting that reply was filed by us.
Yes. So what is the requirement as per law?
As per law, 15 days time that was given.
Read
And
that.
30 days.
Yes.
Yes. Within 30 days of the non-payment.
Yes. So within 30 days, the notice is required to be issued.
Within 30 days, complaints would be filed. Therefore, on 27th, 2018. On 10th February, it.
Yes. So as per your submission, The limitation expires on which day?
10th February. 10th February,
And complaint is filed on
18th.
18th. Yes. Yes.
The applicant here is not actively taking part, and there is no allegation against her in the complaint that how she is involved in the case. It is in general against all the persons. Even in affidavit in chief, that is not stated clearly that who is responsible. The check is at page number 32.
Yes.
It is only signed by the accused number 2. And all the other materials have been typed, and that is done by the complainant himself.
Yes.
Even he has not produced the license for finance business, which he owns. Even he has not produced accounts. Accounts with the complaint, neither with the affidavit in chief.
Yes.
Applicant is not the signatory of the check, and therefore she is not liable to be. Right.
Yes.
I rely
Which are judgment?
Supreme 2013 8 Supreme Court case 71. This is upper. Yes, sir.
Which paragraph you are relying?
Here also the facts are same. Here the facts are also same. Which facts is given on page number 75.
Yes.
The developers, the respondent hearing is a company, now para third. According to the effect in January 2008, since the company was interested in developing a township project and a special economic zone project in and around Panvel, district Raigad, Maharashtra, one Virendra Mahadev Estate Agency, the broker introduced them to the appellant hearing and her husband as the landowners holding huge land in Panvel. They were the landowners in joint name, husband and wife. And the check was signed by the husband.
Here the case is, madam, different. It's a joint account holder. Read para 28.
We also hold that under section 138 of the NI Act, in case of issuance of check from joint accounts, a joint account holder cannot be prosecuted unless the check has
The
been
present case, there is question of joint account. So facts are different. So this judgment may not helpful to.
I will submit the judgment.
Yes, yes, you can submit.
Those are
Whatever.
not with me now.
It can be like this. This is not proper. Then you should make request at the very inception. After consuming this much time, you.
What if I will give those judgments 1 or 2 days?
Yes. So you can submit by way of tendering the judgment, copy of judgment to the court. There is no difficulty. By marking the relevant paragraph of the judgment. By end of the day, you can submit to the. Tomorrow, I will reserve this matter for judgment, subject to
One
hearing
judgment
the
which
other side.
upon which will be identical. It's 2011. 13 SCC.
Only thing you have to explain
Limitation.
about the delay.
Will definitely. Will within one of time. My lord, skipping it just.
Yes, no, you
Yes,
can finish
yes,
the complete.
yes. My lord, if
So
you see,
we-
my lord, everment, my lord, in the,
No need to for
Yes, yes.
re-hearing.
yes,
So,
yes. My lord, the limitation is within, I may explain. My lord, notice is of 24th December 2018.
Yes,
I go by her own everment in the
Yes,
application. Page 16, petition she has mentioned.
yes,
Now, for, if I look at my lord, section 138,
yes,
my lord, I have to first give him 30 days time under clause B. So which would expire on 23rd of January 2018. Then, my lord, clause C of section 138. Drawer of such check fails to make the payment of said amount of money to the payee or as the case where holder of due course within a 15 days from the receipt of that notice. So that 15 days would expire on 8th of February 2018. And then that day, my lord, cause of action would start. And as per section 142, I have to file a complaint within a period of 1 month therefrom. Therefore, my lord, if we count that my complaint as per own everment, which says computer record, is of 18th of February, it is within a period of limitation. And otherwise also now it is, there can be condoned also on a sufficient cause being shown under 140.
that is
Like
not there.
142, there is amendment. And court has not found it to be, my lord, beyond a period of limitation at the time of registration. When an explanation is there. 142. Page. Proviso, nothing. Yes, section 142, clause B, proviso, provided that a column may be taken by the court after prescribed period if the complainant satisfies the court that he had sufficient cause for not making complaint within such period. So if registry was to raise an objection, we could have. But otherwise also, apparently, if I go by her own dates, is it within a period of limitation? It is filed on 18th of February. From 18th of February 2018, I'll get 30 days time to file it.
February.
8th February.
8 February.
And it is filed on 18th of February.
So
This is within the period of limitation. And the judgment which I just placed into service 2011-13 SCC. If viewed in juxtaposition to the fact that in the notice reply, it is not her case. She says that we both are partners, paragraph 3. The theory which is now propounded is for the first time. And in this judgment, the Honorable Court has taken a view that if your paragraph 10 may be seen. Thus, in light of the aforesaid aberments, as found, paragraph 10.
Yes.
Thus, in light of the aforesaid aberment as found by us in the criminal complaint, we are of the considered opinion that sufficient aberments have been made. Again, the respondent, they were partners of the firm. We have also made aberment. There is an admission in the reply also that they are partners. Partners of the firm at the relevant point of time, and we're looking after the data affairs of partnership. The aberment had been specifically mentioned by the appellant in the complaint, even though denied by the respondent, but the burden of proof that an event relevant point of time they were not partners lies specifically on them. The onus is required to be discharged by them by leading evidence, and unless it is proved in accordance with law, in our opinion, they cannot be discharged from their liability. Consequently, the High Court committed an error in discharging them. Also, at the cost of reputation, by virtue of their own submission before the High Court, report is in para 4 above. The report admitted the fact that the appellants had referred to them in their capacity as partners who were in charge of the affairs of the firm at the in the initial complaint. The question as to whether or not they were partners in the firm as on so and so is one of fact which has to be established in trial. Now, in our case, whether he was an active partner or not is in fact to be established during the course of the trial. The moment it says, I am a partner, in my respectful submission, matter would come to an end. And Malone, in the notice reply, which she read on page 65, averment paragraph
in complaint.
In complaint.
Whether
yes, but complaint
partner and active partner.
So that is not required to be in my respectful submission. That's not requirement of law, even though I'll point out that. The complaint page 25. Paragraph 4.
Yes.
આરોપીઓએ સાલુગામ ડેવલપમેન્ટમાં ભાગીદારી પેઢીમાં નાણાકીય જરૂરિયાત અર્થે અમો ફરિયાદીની ભાગીદારી 100% ધિરાણ લેવાનું ચાલુ કરેલ, જેથી ફરિયાદીની પેઢીમાં મતલબ પાર્ટનરશિપ લાયબિલિટીઝ મતલબ of each and every partner mother is joined. To say that I am not an active partner and I should be exonerated is a matter of trial.
Yes, yes. That is-
Then mother paragraph at the end of the paragraph 4, paragraph 5. હાલના ફરિયાદી આરોપી તેના પત્ની બંને ભાગીદારી પર જરૂરિયાત અર્થે.
Why there is some contradictory element in your
No, she has been described as આરોપી અને આરોપીના પત્ની.
read para 3.
Para 3. આરોપી તથા તેના પત્ની આ સિવાય સાલિગામ ડેવલપમેન્ટ પ્રાઇવેટ એન્ડ રિયલ એસ્ટેટ ડેવલપમેન્ટ કંપનીના બોર્ડ ઓફ ડાયરેક્ટર અને ડિરેક્ટર. Additional, I am saying they are also having a business.
There is no connection. with
No
the-
connection, what I'm saying. To show that they are actively in the business.
But, you are not specifically aware about the active partner.
But there is not the
Except,
that's not the
there is
requirement.
now
Because
the-
presumption is
there
there.
are-
141 there is a presumption. Now 141 may be seen. Section 141.
Yes.
Offense of by companies and explanation at the end of the section. For the purpose of this section, company means any corporate and includes a firm or other association and individual. So now in light of that, if you read section 141 subsection 1, if any person committing an offense under section 138 is a company which would include a partnership, every person who at the time of the offense was committed was in charge of and was responsible for the company, for the conduct of the business of the company as well as the company shall be deemed to be guilty of the offense and be liable to be proceeded against the punished. Now in a partnership, to say that though I am one of the partners, I am not actively participating is a matter of evidence. And then in section 139, it shall be presumed unless the contrary proves that the holder of a check received by the check of the nature referred to in the discharge or in part of any debt or other liability. Now their contention, the transaction for some other purpose, that in my respect will be a matter of trial. Cannot be said to
Why
be.
you are not reading para 5 and 6 of your
Complaint.
yes.
Para 5, I'll read. I read my para 5, I read. Again I'll read.
Yes.
Para 5. હાલની ફરિયાદ આરોપી
So there is
તથા
some
તેઓના
element-
પત્ની.
some element to this.
Effect is there,
Of
mother.
course not in a
Well, it's-
many
it's
words,
your-
but there is some element.
So averment is there, mother. It's a matter of then trial. Whether I am
Because now
Am I in a
law is
partnership?
developed to this extent that there must be some element. Not only section is sufficient.
there is
You
a
have to make
moment I
some
say they are partners. In my
For
respect, it's
director
submission.
as well as the partners, there must be some.
In a company, sometimes nominee director may not have a role to play. In a partnership, there is no concept of a nominee partner also. Even there is no concept of a non-active partner.
In view of
A
the
partnership,
Act,
everybody is
they are equally.
Equally. In partnership, it stands on a different footing.
Yes, you can. Any other judgment? you
No,
want
this
to-
is the only one.
Only
There,
one.
honorable court say whether he is a partner or not. There is also a matter of trial.
Yes.
Here, I go.
Yes, yes, by passage of time, sometime they are.
No, there is no further.
Reserve for judgment.
40.
So I am rather dismissing your petition. But subject to.
There is no averment against the petitioner.
Yes, that is your submission. I have noted.
The delay is there and there is no application to condone the delay.
In absence of the judgment you want to cite, I am of the opinion that it is required to dismissal. Since I am, however, I am keeping this matter for dictation day after tomorrow, but tomorrow you can supply the copy. So I can prepare my judgment accordingly.
Please, Romesh.
Day after tomorrow.
Yeah.
For dictation. So your presence may not require. You can just hand over your copy of the judgment by tomorrow morning. Day from this. For orders.
Okay. Mr. Manohar Kumar, Mr. Vajay Patel.
Yes, Mr. Sona. What is the urgency in the matter?
Lordship, your matter is framed for list for framing of charge before law.
Yes,
I'm requesting for pass over.
passover is not possible.
Mr. Patel, he is on late before the another one. I'm not request.
When the matter is called out, learned advocate for respondent is not present. And a request for keep back the matter, considering the size of the board, the request is not possible. To accept the request is not possible. Learned advocate Mr. Sonar has pointed out that there is some urgency in the matter, as the trial court is insisting. Matter is kept on which day?
In the next month, my lord, the exact date I am not knowing, but in the next month, because earlier it was on 14th. But because the honorable court
Charge
had,
is framed or not?
no, it is not framed, but now I will not.
Charge
get
is
any- I will not get any date there. Further date.
yes, the charge is for framing of charge. Which date?
I'm requesting for pass over.
Let it be on second. Meantime, the trial court shall not frame charge on next date. The irrespective of presence of the parties, matter shall be proceeded.
Lordship, second.
2nd August, charge, meantime, the trial court shall not frame charge.
Lordship may kindly keep it. Top on the.
Top of the court.
Lordship, Mr. Surat Kupla.
Yes, Mr. Shukla.
Dear my lords, I am alleged to have attested as a witness in one of the sale deed which was executed in favor of accused number 2.
Why 4 orders matter is? કેમ 4 orders મારી? તો આવી ગઈ એડવોકેટ નોટિસ બજી ગઈ છે આવી ગયા. Earlier Mr.
Shah,
4 orders માંથી કાઢવી પડે. Yes,
the role attributed against me is, my lords, I have attested as a witness.
your IO is here. Yes. Yes.
I have attested as a witness in one of the sale deed which was executed in favor of accused number 2 by accused number 1. My lords, the background of the case is that one of the disputed property, which is bungalow number 34 and 35, situated at Vadodara, belongs to one Johnson Solomon Parmar. Now Johnson had given authority to the complainant, and he was the
other group matters
Yes,
are also
that
there
is fixed on 27th September.
that it, this go cannot, because it is very dangerous to decide that
Object when otherwise.
in isolation.
I'm just pointing it. When otherwise. That is be around.
Please.
27th September with along with number is petition number is there.
Yes, I'll
You
give
are having, because name is very
Solomon. Please, my lords.
yes.
So far,
The power, one is power of attorney and other bona fide purchase like this.
Report is also consisting of 8 pages.
Yes, yes.
otherwise I am not named in FIR. I am only
Only I think charge sheet is filed only against the
Bachu Bhai.
that power of attorney and some other person.
Bachu Bhai and
Bachu Bhai and Mohit
Mohin,
against 3 persons.
On 25th,
27th.
20.
27th September.
27th September.
I'll give the number.
Give them.
I'm grateful.
Order સાથે રાખો, take with કરવાનો. Give the number just now, so it can be.
15 first 15 minutes, Mr. RM Chakawala.
Yes, why you are asking for this?
Serial number 15 and 17. Because the liberty was requested for filing a fresh SCR.
Special criminal, it will take બીજું એટલે
It was not reflected.
એને modified એવું કરવા દે. Withdraw with a view to file special criminal.
Please.
That is what you want, so with a view to file special criminal.
Please.
15, 17.
70.
Both same.
Speaking to Felix, Lordships,
For what?
Lordships, we want to file, we have already filed reply, the pagination was not proper, so I was to done the pagination.
So instead of petition, affidavit in reply is required to.
Please, yes, affidavit, pagination in affidavit reply.
એમાં આપણે કઈ કેવું લીધું છે petition it's along with affidavit એની બદલે affidavit in reply છે એટલે.
Please,
That is what
yes, sir. And I have quoted the portion also, so that, please,
allowed.
please.
Mr. Amar Goldie, Mr. Hidey Buch, Mr. Nisip Gadri, Mr. Udit Mehta.
Yes, Mr. Butch,
Yes,
sick note of,
Mr. Buch.
he is here.
I'm here.
Yes.
Good difficult. So the other side also.
Now season,
Not a season. Because I appear for two accused, my friend appears for, and there's one more,
who is,
Mr. Bhavsar probably. And for
what is
respondent,
matter, 306, 384. So you are money lenders,
some allegations are that page 8 is the FIR.
license is
So that is not, Manoj may kindly have page number 8. But that is the FIR, also show how, let's, initially
page,
8 is the FIR.
first matter 16 is the.
I'm sorry, my is
MR
1/4.
Molvi. Bhargav Karya and Hriday Buch, yes. So why one petition is of 15 page and one petition of 7 page? Depends on advocate.
No, here, sir, here, because
He
I,
is having many grounds.
sir, yeah, એટલા માટે, because here the deceased had issued check which was bounced. Proceedings under 138 were initiated. બધું સાહેબ રેકોર્ડ ઉપર છે therefore. એટલે થોડીક વધી ગઈ બીજું કાંઈ નહીં.
Yes,
Yes,
who is complainant?
probably Mr. Gandhi, yes, yes.
Mr. Gandhi.
Mr. Gandhi.
Nishit Gandhi.
So whether you are having any license of money lending?
No, sir, that is not the case, but probably that is why I was taking my loss. Sir, check was issued in lieu of transaction with regards to land that was bounced. 138 થી ફરિયાદ થઈ અને એ પછી સાહેબ આ થઈ. FIR માં they says that 4 થી 5 શખ્સો. Thereafter, name of 23 persons are reflected. And look, there are just
Suicide note is there.
suicide note, yes.
What name is there? After that, 23 people has been added, Lordship.
That can be by
Suicide note, yes, but then there is
if
no,
some more material is there, then it can be added. You know.
there, in fact, there is affidavit also is there, except denial, there is nothing.
How they can
Therefore,
on
when,
these details. Let the IO can
because
be.
we will also take,
IO is here.
we also take.
Let it be go on some other day. How many meters?
Probably
Four.
3 minutes.
4 meters.
More matters.
Who is appearing for the Nishit Gandhi? So you are ready with the matter?
Our reply is also there.
Reply, there is nothing in reply. On that count, matter is required to be allowed.
There is suicide.
Friday, top of the board. Irrespective of the leave not sick note.
Monday, Tuesday, Lordship, the
Yeah.
Friday.
Not Friday is not good. Right?
No, it could have some personal. Monday, Tuesday, any day, Lordship.
19th August, top of the board.
I'm grateful, Lordship. No, we got the to file appropriate application from the.
Fix permission to withdraw it.
No, What's going to happen?
એવી નહીં લખ્યું બાકી બધું લખશું છેલ્લી લાઈન ખોટી એડ થાય યસ
Liberty Bank. 24 Mirza, Adil Mirza, 600.
Just for the requirement of the date, Malad, it is adjourned to 2nd of September 2023, Malad. The thing is, Malad, now the matter is settled. And that's why, Malad, we have some urgency in this matter. And therefore, Malad, we have some urgency. So if my lord may report the date of hearing. It is adjourned to 2nd of September 2023.
Requirement.
Yes, Malad.
This is for requirement.
Yes, Malad. Next week, Malad.
September સિવાય કઈ થાય એવું જ નથી.
So it is settled. That's why, Malad, it is under section
Settled.
380 and 120 beyond. It is settled. That's why, Malad.
Where is the complainant?
Complaint is today is not present. If my lord may fix the date, my lord, next week, my lord, he will be
You
here.
should keep that one. Second of the board
I am obliged, my lord.
allowed fixing date.
25 Mr. Mahito Singh, Mr. Ahmed Sakawat.
Yes, sir.
302, my lord. Difficulties, my lord, the trial is going on.
Trial is going on then. Not press with a view to avail all the contention before the trial. Upon it.
26, Dilip Kumar Prajapati,
Restoration लंबी तारीख में September first week.
37 Mr. Saurabh Mehta, Mr. Anthony.
Please, Your Lordship.
Yes, yes, sir.
Lordship, the FIR is at page 45, Your Lordships. The applicant herein is the accused number 1. The FIR is dated 24/5/2021. The offence is punishable under section 406, 420, 465, 471, 120B, 167, 409, 468, and 467. The allegation against the present applicant is that while working as a district planning officer, he has in connivance with the other accused persons, he has disbursed the amount of the fund of MP for the development in wrong account. And the total allegation, the Lordship may kindly.
Your IO is here.
It's 7, I know it's better.
Yes.
Yes, that is, I'm coming to that only. I'm coming to that.
Also been filed. Statute not been filed, I don't get. Around 97 lakh of misappropriation of the fund.
Yes.
Yes, sir. And Lordship may kindly see the total allegation of 97 lakh, but Lordship may kindly have it for a moment. Page 206, my additional affidavit. 290, I'm sorry.
Yes.
On page 226, before at least 6 months of filing of the FIR, on 23/12/2020, on numerous occasions, I have sent communication to various authorities and the concerned department, to the learned collector, all the authorities, that my signs are forged and making my signs, the amount is disbursed. Even there is handwriting expert opinion also, that is private handwriting expert opinion, but in the departmental inquiry proceeding as well as on number of occasions since 2020, I am requesting all the authorities to kindly give my specimen signatures for FSL, because admittedly the signatures which are there in the disbursement list is not mine, and there is clear difference can be seen from matching both the signatures. It is apparent difference. And the role of the Roshni Patel, which is enlarged on anticipatory bail, role of Roshni Patel is almost similar to my role. At the most, I can say that role of Roshni Patel is much graver than me, because I have put up 32 years bloodlet service, and whereas the Roshni Patel was working as a contractual employee, and she has signed, though she was having no authority at all to sign those documents, she has signed, and by making sign on my behalf, the amount was disbursed. So in my respectful submission, since I was availing the legal remedy, I have not surrendered, and I have not, that is not that I have not cooperated with the investigation. Lordship may kindly for a moment turn to page 87. Page 87, Lordship may kindly help. During the investigation carried out by the CID crime, there are 3 statements recorded. I have given 3 statements before the CID crime.
How I can appreciate all these things in the
Lordship, only
482.
today my request
Raise
is
the
only,
trial and get the acquittal.
Lordship, may kindly see. Today is my anxieties. Lordship may kindly protect me. I will appear before the IO, and I will give my specimen signature for FSL.
Whatever you
Continuously,
want
Lordship, I am making a request that my signature may be sent
to,
for
can
FSL.
do whatever you want to do during the trial, not at the.
And Lordship,
Why I
even
should exercise my discretion?
because your Lordship,
There
may
there
kindly
is
see.
apparently you have put up the signature, rightly or wrongly. The allegation is that you have
Yes.
made the signature.
Lordship,
Now
my
you
request
can
is twofold.
make necessary arrangement during
Yes.
the trial.
Lordship, my request is twofold. I was under suspension, and my headquarter was Bhuj. The police authorities as well as all the relevant authorities were aware that I am placed at Bhuj, but I have cooperated with the investigation. On page 111, I have also sent a written statement, my written statement to the IO. This is not there. My version is not on record. And everything is documentary evidences which are collected by the IO.
You
So
can
only-
file appropriate proceeding if requires. You can file
Yes, I
separate
will-
petition for that. That if they are not acceding
Yes,
to your request.
I will file those
Whatever
proceedings.
it is.
But your Lordship may
It's
kindly
not
appreciate.
case of Kaushik. There is
Let-
prima facie material against you, Mr. How I can
But Lordship may kindly see.
looking to the gravity of offense, I don't want to.
Looking to the gravity of the offense, all the accusers are released on bail, your
But a
Lordship.
bail is a different
And
thing.
Therefore,
The
my only
coercing
request is
a
I may
different
appear
thing,
before
Mr.
since the issue of my availability is concerned, I may go
There is
before
no
the IO.
difficulty about availability or not, but you have to face the trial.
I will face. I am not saying for a moment that I will not face the trial, your Lordship.
This is for that very
And
purpose.
there is no my learned friend
It's
may show.
not no case for quashing. That is for sure.
I followed your Lordship, but the other side may show anything from
I
the
don't
record
want to-
that
you have
there
follow
is
up on it.
single evidence against me.
From reading of FIR, I am not convinced that.
And at present-
you are required to be all these
Please.
things which are now putting you forth with. It's your defense. And
Please, sir.
defense
And
cannot
at
be
present-
examined at this stage.
At present, your Lordship, the entire case is based upon the signatures. I have in the departmental
For that,
proceedings
there is
also.
a process. You have to establish that it is not your signature.
But
How
therefore,
I
have
can
made-
examine at this stage in
Please,
this
Lordship,
process?
I have wrote number of communication from 2020.
Yes,
Then
yes,
my
yes.
signatures may be
You
obtained.
can file appropriate proceeding for seeking that prayer if they are not acceding to your
That is the
request.
precise prayer in this petition also, your Lordships. Lordship may kindly see my prayers. Lordship may kindly see on page 42. 43, your Lordship. Lordship may be pleased to issue appropriate redirection upon the investigating agency, directing it to obtain specimen sample or signatures handwriting of the present petitioner and to carry out the scientific test and handwriting expert by comprising the same with the elite checks documents, and the report of the same may be presented before this honorable court within a stipulated time as we prescribe with this court.
That is how to question. Why
Because,
I
your
should
Lordship-
exercise that. You can go before the court and file appropriate proceeding.
I will go, and I am not.
Your
Lordship may-
prayers
Lordship
are, you have clubbed up all the prayers in one petition.
Please, Lordship may kindly appreciate that I am as on today, I am not saying for a moment that I will not face the trial. But my signatures are forged and I am made the scapegoat. And since 2020, I am making a request, and it is upon my request, since I have made the number of communication, this fraud is came out. And therefore, your lordship, my only request that I may be I will appear before the IO. I will give my statement. Though I have given 4 statements in
Yes, yes, I will record that you will appear before the IO
and report
give
in
the
my handwriting.
necessary statement, and then, but I am not inclined to grant any relief. If you
Lordship,
want to withdraw,
my-
withdraw, otherwise I will pass appropriate.
I followed what is following from my
I will
lordship.
say that all the other contention will kept open. You can press all these contention in service, but why I should pass any order?
Otherwise, lordship, may kindly see on number of occasions I have with my additional affidavit.
Yes,
There
yes,
is approval from the
but
Home
that is
Department
your
also as
defense,
per the
mister.
police
You have to
manual.
establish your defense by go for the
No.
private.
There is report of private handwriting expert, and as per the police manual, lordship, Home Department has given approval, but the concerned secretary is not
They will
doing
do
anything.
needful at the time of recording evidence. This statement, you can produce all these documents.
I will, but
They will
my
examine
only
and they
request
will
was-
do needful in.
But-
Why I should direct them to
My
what to do.
only request to
They are
lordship
the
is
best
that,
person to.
yeah, I will appear before the IO on any date which your lordship may fix. I will
Why-
give my
I
specimen
don't-
signature, and thereafter
today
lordship may
this-
kindly,
this-
after
today
perusing the
this
report.
proceeding will be over. By way of order or by way of withdrawal.
That I follow, but only as a last time I am repeating my request that after perusing the report of FSL, lordship may kindly take any appropriate
No,
decision.
no. You
Otherwise,
can go
I
before
have
the
to
trial court. Why
suffer
I-
for no fault on my
Even
part.
FSL report is here, I cannot examine at this stage.
Please.
In such a matter, I can understand in a given case, we can examine, not in such matter.
In that
Where
case,
there are ample material, other material, which is required to be tested during at the time of trial.
otherwise, your lordship, the role of Roshni Patel is
Yes,
very
yes,
similar.
but that can be tested. Everything can be.
Then in
Whether
that
you are
case-
convicted.
No,
Yes.
but for no
You are
fault on
having
my
a
part,
good
I will
opportunity.
have to be
Yes.
behind the bars.
You're in 482.
Therefore,
I'm
only my
having a
request, I may be
limited,
protected, and
yes.
if it is found anything against me, then I will go behind the
That-
bars.
That has to. Then every accused will say like this. Then
No,
no
sir, but
trial is
in this
required to
matter,
be.
your lordship, I have number of
No trial is
less than-
required to be conducted. If that
Not
is
less than
the-
25 communications I have made. Even the Home Department has given its approval, but the secretary is sitting tight over the file, and he is not sending for FSL.
Yes, yes. You
And
can-
therefore, my only
I will
request to-
record your statement that you will approach the, and with a view to record statement, you will go there and they will do needful.
may I request in that
You are
case
not pressing this
for
petition.
230, your lordship, for taking instruction.
230.
Please,
Seconds.
please, your lordship.
Consent posting. જે બીજું લેવાનું પછી recall બાકી હોય consent posting.
Consent for 6%. Detail number 45. Mr. Mehul Suratha, Mr. Nazmuddin Leknani, Mr. Dharam Rao.
Some other person has also mentioned, somebody who has mentioned this after your mention. On behalf of Mr. Sir, somebody has mentioned. No, I am happy that they are, you are so active that. Yes, there is.
Complaining.
What is matter about
Dispute and succession entry dispute. So now it is settled between the parties.
between the brothers?
No, between me not, because our say that we are legal, yes, they are saying that they are legal, yes, but ultimately now it is settled.
સમાધાન થઈ ગયું છે આવો આ વકીલ સાહેબ પાસે આવો તો ખ્યાલ આવશે
જી સાહેબ સમાધાન થઈ ગયું
શું રકમ મળી
ના land
લેન્ડ જે હતી જે ડિસ્પ્યુટ હતો સેટલમેન્ટ થઈ ગયું
એટલે શું થયું છે
જે અમારો હિસ્સો હતો એ અમને મળી ગયો
હિસ્સામાં શું
property. જી sir.
તો તમારો હિસ્સો હતો એટલે
હા એટલે power
તમે
plant તરીકે
ખોટી ફરિયાદ કરી હતી કે સાચી
ના સાચી છે.
દાવા થયા છે કે
ના દાવા
દાવા નથી. ખાલી ફરિયાદ જ કરી છે. હવે કઈ રહેતું
ના ના
નથી
sir.
સ્વેચ્છાએ કરો છો કોઈ દબાણ
ના
નથી
કોઈ દબાણ.
complainant is present. You are appealing for the complaint.
Please, madam.
Wakalatnama is filed.
Wakalanama is fine.
Serial number
Hello.
45, another matter is also listed. That is 3742. That I had moved for registration of FIR. So that I am withdrawing.
3742 is withdrawing in view of this. સાથે જ છે. List 3 જ પણ.
Any of this formula. One 38, Mr. Jigar Kadmi.
Yes, Mr. Piru. Where is complaint?
Appearing for the complainant.
The case is where the
Offense under
366, 363, where both were majors, they had eloped, but the marriage was opposed by the father. Now the situation is that the daughter is also getting a job in a department. Now the father feels that yes, then now they are happily settled. It was an incident of 16, married in
now
16,
happily married or
happily married. They are together. Marriage certificate is also there on record. The
there is a
daughter is also
complainant.
complaint is the father.
એટલે બોલાવો તો ખ્યાલ આવશે. તમે તો તમારી બાજુમાં ઉભા રાખો ને complaint. શું નામ આપનું? હવે શું તમારે નથી કઈ આગળ ચલાવવું કામ? કેમ? ફરિયાદ શા માટે કરી હતી? પાછા આવી જાય તો પાછા તો આવી ગયા ને. અચ્છા કામ આગળ નથી ચલાવવું ને ફરિયાદ. કોઈ દબાણ નથી. સ્વેચ્છાએ કરો છો. ફરિયાદ રદ થઈ જશે આનાથી વાંધો નથી.
I may be permitted to file my weapon.
Mr. What is your good name?
Jignesh Pandav.
Jignesh Pandav. Within 2 days, registration accept.
Please, madam.
Please.
Number 8. Nanavati and Nanavati. Vandan Bakshi.
Actually,
IO is
allocated this type of thing. That will be kept at 230 only, madam, because in advocate only terminated to event and then 230 for John. He's on his leg. In fact, I also on his way, he will be here.
230. આગળ કોલ કરો ફટાફટ.
One continuous. Number 28. Mr. Deacon Popat.
Please.
Yes, Mr. Purdy.
Please,
Direction for what?
the senior officer of the department is present to my law. The device he was followed. Looking into the matter, I may not able to submit certain aspects. But we are very close to catch this accused number 1. Being able to get his whereabouts. We also get permission from our department to go at that place because it is out of Gujarat. I will inform that if 1 week further can be will able to further locate. From where be able to locate that, I'll able to show it to my lord.
Also, before my learned friend makes further submissions, my clients pursuant to investigation or otherwise have instructed me to withdraw the matter. I have told them I will not be in a position to withdraw. My conscience would not permit me to withdraw this matter.
So I will be giving my no objection to them. They may engage lawyer, or then it will be between the court and the lawyer. I am not in a position or
difficulty.
yes,
If you withdrawal is how a court can. refuse
because in this
withdrawal
facts,
of-
my lords, at least
you.
correct. Therefore,
Yes, yes.
therefore
officer
it can
of
be
the
kept
court,
next week. In the meanwhile, my
if your
client can also.
conscience is not.
I will not
permitting-
be in a position to request the honorable.
Looking to the totality.
Yes, it is unfortunate, but I am also bound by my instruction, and that
Yes,
is
yes.
how I am. I have said no.
So,
Therefore, it
Who
can
is
be.
paying for the?
No, they have still not been able. Today morning only they told me. So I told them that you please make alternative arrangement. I will not withdraw this matter.
Yes, let it,
Fair enough. Therefore, it can be kept next week. Otherwise, also, and
But let him submit the
yes, please, Maharaj.
This is the alternate
report is
report is there. Report.
just give the report.
This is a report. Progress report. And my lords, just for my lord's benefit, be able to. Try to locate from reasonable sources. I will not even say what which sources, because
Since he is having some instructions, so I am passing some order. When the matter is called out, the pursuant to the earlier order dated 1/7/2023. The IO is, what is the
IU is accept Mr. Parmar.
DYSP is here?
DYSP now examine, under his examination, madam, IU is.
He is also
He
here,
is also present.
the DISP as well as IO. Concern is also present. People are also present before this court. And learned APP has submitted a report prepared by DYSP, Mr. VR Bajpai, Nadia Division, which is taken on record. And Mr. Learned APP on instruction has submitted that they are in view of the earlier order, they are further investigating the matter in proper direction and need some more time to give to place the outcome of the such investigation. Learned advocate Mr. Popat submits that he has received a request from the client to withdraw the petition, but he is not.
May I only request that your lordship may say that I'm
No, I will
Fair
ask your client to be here.
easier. He is present.
Where is he? Only. Court is not meant for this.
I
Either he should have courage to.
exactly. That is what felt, but I am also
Yes.
bound by instructions.
આવો ભાઈ શું આપને કેવું છે કેમ શું એટલે આ કઈ રમતનું મેદાન છે કોર્ટ પરિવારને કોણ તકલીફ આપે એવું છે સમાજ શું કામ તકલીફ આપે તો તમે આવું બધું કરતા પહેલા નહીં વિચારવાનું આપણે ક્રિકેટ રમો છો ક્રિકેટના મેદાનમાં છો તમે આ કોર્ટ છે સમય એનો હોય તમારી 1 મીટર પાછળ કેટલો બધો સમય એમને અમારે બોલાવવા પડે તમારે આ બધું જો તમારે કોઈથી ડરવાનું હોય કે કોઈના દબાણમાં રહેવાનું હોય ને પછી તમારે ન કરવાનું હોય તો પહેલા તમારે વિચારવું જોઈએ એવું નહીં હું પરવાનગી નહીં આપું તમારે ચલાવવી પડે તો ચલાવવી પડે એવું ના ચાલે તમે દબાણમાં છો એવું લાગે છે તો તમે કહો છો કે સમાજ એમને દબાણ કરે છે
મારા કુટુંબ હોય ને ભાઈ
તો પણ બધું તમારે પહેલા વિચારવું પડે ને ભાઈ આપણે શાકભાજી લેવા જઈએ ને વિચાર આવે કે ભાઈ હવે રીંગણા ને બટેટા લેવા છે કે નથી લેવા અને પાછા આવી જાય ચાલે આમાં ના ચાલે આ કઈ કોર્ટ છે કોર્ટની કાર્યવાહી આવી રીતે લાઇટલી નહીં થાય તો કા તમને દંડ કરવો પડે કોર્ટનો ટાઈમ બગાડ્યો. માફી શું એમાં તમારે આમાં એવું તમે આવું દબાણમાં આવી જાવ એનો વિરોધ છે. તમારી બાકી ઈચ્છા હોય મેટર ચલાવી ન ચલાવી તમારી ઈચ્છા હોય, પણ દબાણથી તમે પાછું ખેંચો એ બરોબર. દબાણ જ હોય. જેવું ઇન્વેસ્ટિગેશન આગળ વધારવાની વાત થઈ એટલે તમે તરત પાછી ખેંચવાની વાત કરી. અત્યાર સુધી કઈ તપાસ નથી થતી એટલે ત્યાં સુધી તમે એમને શાંત બેઠા. ત્યાં સુધી તમને નતો વિચાર આવે ને? તો હવે કેમ તમને વિચાર આવ્યો? કારણ કે કોઈએ દબાણ કરેલું છે, કે પોલીસ વાળા તમને દબાણ કરે છે, કે તમને જે આ આરોપી ના જે છે સંપ્રદાય એ તમને દબાણ કરે. રાજી એકદમ કેમ આવ્યો તમને એ નથી સમજાતું. આવું ના ચાલે. કોર્ટની કાર્યવાહીને તમે આવી રીતે લાઇટલી લ્યો તો કઈ રીતે ચાલશે? ખોટો એક અમે પણ એના એક ભાગીદાર બની કે આ ખોટી એક પરંપરાના. અને કોર્ટનો કેટલો ટાઈમ કેટલા વખતથી ચાલે છે? 2-3 વખતથી તો હું સાંભળું છું આ મેટર. એ પેલાના સાહેબોએ સાંભળેલી. શું કરવું છે વિચારી લો. એવું ના ચાલે ભાઈ, આગળ નથી ચલાવી. Take his affidavit.
He may make alternative. I will not be in a position.
At this stage, Mr. Popat has submitted that his client is not willing to continue. Is not in a position to continue in the with the proceeding in view of the some instruction received from client. Therefore, and client is also present. The court has inquired the client. What is your good name?
Bhavesh
Lalji Bhai. He has submitted that. તમે અરેન્જમેન્ટ કરો બીજી, પછી તમને પાછી ખેંચવાની. આ વકીલ સાહેબ તો ના પાડે છે.
Yeah, I already did.
એટલે તમારે વ્યવસ્થા કરવી પડશે બીજી, કોઈ વકીલ નહીં. પછી પાછી ખેંચી. બરોબર. Let the release this matter after 2 weeks. 2 અઠવાડિયા પછી રાખી છે. કઈ તારીખ આપો? 17મી ઓગસ્ટ. ત્યારે બીજા વકીલ સાહેબની વ્યવસ્થા કરવાની હોય કરી રહ્યો. આ વકીલ સાહેબ છૂટા થાય છે. File your note also for retirement after taking necessary steps.
Obligation. And sorry, my lords, but conscious said not to.
No. It's a gross case where
Yes.
apparent that something is, which is not gross.
Please.
વિચારી લેજો ફરીથી. તમને સમય આપ્યો છે. એવું કોઈથી ડરવાની જરૂર નથી. હા?
Obligation.
સવારે હતા ને સીબી ઉપરથી સવારે હતા એ કોણ હતા? ચિરાગ હતા. અચ્છા. સીબી ઉપરથી બીજા. There are other matters also. Group. There is one group is also there. Entire group હતું ને તત્વજી જાની વાળું છે ને? આજ છે ને? આજ છે ડિફરન્ટ છે. યસ. જયારે રાખ્યું હોય ત્યારે રાખો.
On next, it's pertain to 138.
Not possible. Next week is not 19th.
Number 32, Mr. Prema Raj, Mr. Excellent.
Yes. Mr. Raj,
Please, Your Honor.
what is matter about?
This is for quashing of FIR, which is filed after a period of 1 year. And that too by suppressing the fact that already the amount which is alleged to be misappropriated has been repaid by the concerned parties. The allegation is to this effect that in a scheme which was launched by the state government for construction of check dams in Bhavnagar district, the contract was given to several contractors, including the present petitioner. Now, the check dams were constructed, 11 check dams were constructed, one of which was constructed by the present petitioner. Out of those 11 check dams which were constructed, because under the scheme, the district development officer was appointed as the project director and a nodal officer was appointed and a committee was formed. After carrying out this construction work, the work was allotted through tender process. After carrying out this work, completion certificate was also issued to the present petitioner. The payment of rupees 2,40,000 towards this construction was paid to the petitioner. That your lordships would find the work order at page 5.
So you are contractor.
Yes, I am one of the contractors. There are in fact several accused persons, including the contractors and as well as the nodal officers and others. Now, allegation is to this effect that the check dams which are constructed, which are 11 in number, in 5 check dams, the work was not done as per the specifications, and therefore total amount of recovery which was demanded was rupees 1,45,000 in respect of these 5 check dams. This demand was made by the district development officer from the nodal officer. That show cause notice was also issued 1 year prior to the date of FIR. After receipt of this notice, show cause notice by the nodal officer in turn issued notice to the contractors that this is the amount in respect of the present petitioner, amount of rupees 35,000 was sought to be recovered. 35,000 I paid back to the nodal officer, which is lying in the bank account of the district development officer. After 1 year thereof, FIR is registered.
Your IO is here. So you have no coercive action, but investigation can go on.
I have taken instruction where me charge sheet is not filed.
That was fine. Statement will be there with us. They'll call it.
All the which are necessary. Learned FPP shall call for the report from the concerned investigating officer with necessary documents. To release this letter on 19th.
Please, Your Lordships. I'm grateful.
Yes, Mr. Karan.
I was on my leg before the dividend bench appeal is going on. Therefore, lordships may kept it matter on 2 of August. But meantime,
Yes,
lordship may
second.
directly charge may not be framed. But here the facts is remains. The accused person's court time before the trial court on the ground of matter is pending before the high court.
Let it be on 2nd August. क्या है दूर से क्या सुधी चार्ज नो प्रेम साइड पर कहीं तकलीफ है. Let it. Yes.
I'm sorry, serial number 45, I think it was first time. One of my matter was there. I was for the respondent. That has been already disposed of.
Yes.
Serial number 45, it was consent quashing.
Yes. Yes.
And in that, I was for the respondent, there was one matter which was tagged. My absence and
Yes. Yes. That he has withdrawn.
Yes,
That
yes.
is that.
but since I was
No
another court-
absence is recorded.
And lordship, serial number 46, next matter
Yes.
is of Mr. Yagnik. In that matter, I am for the respondent matter.
Yes.
Since yesterday also I had a word with him. He's also said that I also have to take some instruction whether this matter, no coercive is there, but investigation.
Let it be on some other day.
Yes, so any short
Now,
date.
it is very difficult to proceed with the other matters.
Right.
Supplementary board.
So if my lord may give any short date,
Yes.
that is my request. Obliged.